Hello everyone, my name is Catherine Newell. I'm a partner with Griffin Newell LLC, and I'm so excited to talk to you all today about protecting the educational rights of students with disabilities. And I certainly want to begin by thanking AdvocacyDenver for hosting this webinar and making it available to everyone. I'm really excited to share this information. So just a couple of housekeeping things. This is a two-part presentation. The first part is going to really focus on identification of students with disabilities who may be in need of services in school. And then the second part will have a focus on school discipline, primarily expulsion. I'm going to do the first part, and then we'll just move on to the second part, even if it's a little bit before 2:30 when we start the second part. You're welcome to send me questions as I go along, and I will try to answer them either during the presentation or at the end of each part, depending on what seems like the best fit. Also wanted to mention that this webinar will be available online afterwards, and we will also have an informational handout available with some common deadlines in education law. So without further ado, let's get started. So I wanted to start by giving everyone an overview of the presentation and kind of let you know where we're going to be headed. The first part is going to focus on the rights of all students in public education K through 12. And then I'm going to talk specifically about Section 504 of the Rehabilitation Act of 1973. That's a federal law that prohibits disability discrimination. And then spend the bulk of the time talking about the Individuals with Disabilities Education Act, or IDEA. Since I'm a lawyer, there's of course a disclaimer at the very bottom, and just wanted to remind everyone that this is a presentation with general information about certain topics. Education law tends to be highly fact-specific, so I'm not going to be talking about any particular situation. I'm just going to kind of give an overview of some common topics, and certainly if you have questions about common topics, those are the ones that I would be able to address. So, little introduction to this diorama. I'm a visual learner. I find it helpful to have an image of how all these various laws hang together. I will say, you know, I think when you're talking about education law, there is a real tension between oversimplification on one hand and getting so far into the weeds on the other that you can't cover a lot of ground. I've certainly erred on the side of oversimplification in coming up with this model, and in terms of some other things I'm going to talk about. So the first part, what we're going to basically do is kind of start with the big circle, the rights of all students in public education, and then talk about a subsection of that population that may be protected under Section 504 of the Rehabilitation Act and another federal law, the Americans with Disabilities Act, and then in general, a subset of that population that has some additional protections under the Individuals with Disabilities Education Act. That's kind of the way the presentation will flow. But I think also this model gives you a sense of how these various legal protections interrelate and nest together. And probably the most important takeaway is that students with disabilities are students first. So all the kinds of various state, federal, constitutional protections that might apply to a student in public education could also apply to a student who has additional protections under 504, Title II, and IDEA. So there's layers of protections, but the important thing is, I think, is to not forget that there may be some other rights that aren't disability related, but which could apply to a student with a disability. On that note, we're going to start with the first big circle, rights of all students in public education. Here's just a few examples. There's many things I could put into this big circle. So I think some common ones that most people are familiar with are constitutional rights. First Amendment, free speech in school has been a hot topic that's certainly had years of litigation. Fourth Amendment, search and seizure. This comes up, for example, in situations where an administrator wants to search a student's person or their backpack or their locker. 14th Amendment, equal protection. Many other rights perhaps are protected by the Constitution that can apply to students. I also referenced the Family Educational Rights and Privacy Act, known as FERPA. We're going to touch on that a little bit more in the second part of the presentation. I'm sorry, part two of the presentation concerning school discipline. But some common things to know about that is right to access records, right to privacy of records, right to challenge the accuracy of records. Those protections also apply to all students in public education. And then as sort of a preview again for the second presentation where I focus more on expulsion, I'll be touching on a lot of rights that apply to all students. So that's an overview of that topic. Since we're focusing on general protections for students, I wanted to mention a topic which is not necessarily a legal protection, but is a broad general education program. And this is multi-tiered systems of supports, MTSS. Other states have similar types of programs that are often referred to as response intervention or RTI. The reason why I wanted to mention this program is I think there can be a lot of confusion between MTSS and 504 plans and IEPs. And so in case you wanted to know where does MTSS fit into this whole scheme, I wanted to touch on that. So what MTSS basically is a general ed program with layered continuum of support, and districts may have any number of different versions of it, but the concept is when students are struggling in school, a school district may decide to give them some interventions, collect data to see if those interventions are effective, either continue with that level of interventions or perhaps increase, and then same thing, collect data, perhaps increase into to additional interventions. So in practice, this can look like, a student who's a struggling reader getting a small group, additional reading instruction in a small group setting for, let's say, 30 minutes per week. And you collect data, they're still a struggling reader, they get a little bit more reading, et cetera, et cetera. I think the key kind of takeaway is if a student is receiving support through the MTSS system, that is not synonymous with a 504 plan or with an IEP. You do not have the same kinds of legal protections. And it's not necessarily an adequate substitute for a 504 plan or IEP. So I think if somebody has a student who's receiving some additional intervention at school, it's really important for parents to understand how exactly is that service being delivered, what is that model, so you know where you are in the process and whether or not that particular program is sufficient in terms of support. So we're going to move on to the middle green circle, Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act. And I've also mentioned on the slide the Colorado Anti-Discrimination Act, which is a state law that similarly prohibits discrimination on the basis of disability. So all three of these laws, the two federal law and the one state law, have a lot in common and some really important differences. So what they have in common is that at their core, the primary purpose is non-discrimination and equal access, equal opportunity to services. Section 504 applies to recipients of federal funding. So not necessarily just government entities that get federal funding, but it could be other types of entities, nonprofits, et cetera, that get federal funding. Title II of the Americans with Disabilities Act applies to state and local governments, and the Colorado Anti-Discrimination Act applies in a number of different categories, including places of public accommodation, such as schools. So you can certainly, picture a scenario where more than one of these laws might be applicable. For example, a public school district, which could be considered a local government entity, but that also receives federal funding, both 504 and Title II may apply. And as I mentioned below, these laws are similar in that they all prohibit discrimination on the basis of disability. So how do schools meet their requirements under say Section 504? The main way is through a 504 plan. So a 504 plan has, again, some similarities to individual educational program, which we'll be talking about in a minute, but some pretty important distinctions. I think one of the kind of the critical distinctions is that, I guess I would say there's sort of two areas where there's some major distinctions. One is the evaluation process to determine if a student needs a 504 plan. And then the second, I think, area of real distinction are the procedural protections through 504 as compared to the IDEA. So, and we'll talk a little bit more about that. So starting with the evaluation process, certainly a parent can ask for a 504 plan if they feel that their student is struggling and needs some accommodations or services in the school system. Also, the school district may initiate that process. For the evaluation, the school district shall draw information from a variety of sources. Some examples are tests, teacher recommendations, physical conditions, social, cultural background. Certainly the parent can present information from a medical provider to the 504 team. This, unlike with the IDEA, the school district does not have to administer its own tests. So if it does decide to do that, it needs to make sure that the tests and evaluation materials that are used meet certain requirements. For example, that they're tailored to assess that specific area of educational need, but it doesn't necessarily have to administer its own type of evaluation. The placement decision is made by a group of persons who are knowledgeable about the child, the meaning of the evaluation data, the placement options. It doesn't specifically have to include parents, though in practice, I think that school districts, I think in every example I can think of, they would invite a parent to that. But one reason for doing that is, the parents have rights under 504 and might challenge the decision of the school district. So I think it is appropriate to include the parents and address their concerns in those meetings, as opposed to doing this behind closed doors and then waiting for a challenge. There's also a requirement for periodic reevaluation. And we'll talk a little bit more about that in the context of school discipline in the next presentation. So some components of a 504 plan. There is a presumption that the student should be placed in a regular educational environment unless education of the student cannot be achieved satisfactorily, even with the use of supplementary aids and services. This is very similar to the IDEA, which has a concept of least restrictive environment. The idea is that when in doubt, a student with a disability should be with their non-disabled peers. And also, it's it'd probably be inappropriate to move that student to a different environment if you haven't at least considered whether they can be served in the regular ed classroom effectively with supplementary aids and services. Another component may include related aids and services that are designed to meet the student's individual educational needs. In practice, what you typically see with a 504 plan is a list of accommodations. So some very common accommodations might be extra time for testing, minimizing distractions, perhaps a number of different things that may be successful for helping a student access education in a way where they're not impeded by things that are going to aggravate their disability. So I'll just say that I think that that's often 504 plans are pretty common. For example, when you're talking about a student who has ADHD or has dyslexia, and particularly if the impact of those disabilities aren't particularly significant and they just need some tweaks and how they're able to access education, typically accommodations may be sufficient. Also under 504, there should be equal opportunity for non-academic and extracurricular services activities. School districts must ensure that the student can participate with non-disabled peers in non-academic and extracurricular services and activities to the maximum extent appropriate to the needs of the student. So this provision can get triggered, for example, if you're talking about field trips. If a school district wants to exclude a student from participating in a field trip just because it's kind of a hassle for reasons related to disability, that may very well run afoul of the protections under 504. These, like I said, are just some components under 504, and sort of as I've mentioned previously, I think 504 is often a more appropriate means of addressing a situation where the student's disabilities are relatively minor, that it doesn't, they're not really in need of significant intervention. I think that the 504 process can be an appropriate way of addressing those needs. But typically when you're looking at students who have several different disabling conditions, a very complex situation, particularly students who need access to modifications in their curriculum or the way the curriculum is delivered, that's where IDEA is usually the more appropriate way to go. So with that segue, we'll move on to the IDEA. And I wanted to touch on the fact that in Colorado, the IDEA is implemented through state law known as the Exceptional Children's Educational Act, the ECEA. And the reason why I decided to use a picture of a coloring book and some colored pencils is it's pretty, but also I wanted to try and have a good visual image for how the federal and state law work together. So IDEA, federal law, has some bedrock parameters that states have to comply with, but also in the IDEA, there are various areas where states have some discretion. So the way I think of that is picture the federal law like the lines in the coloring book, right? This is the outline, but you can choose whether you want to color that leaf red or green. So in the analogy would be you can choose under state law if you want to implement it this way or implement it that way to some degree. But if you start coloring outside the lines of the coloring book, then or violating federal law, then you might have a preemption issue. So that's kind of how I think of these things working together. So the key issue, but before when we talked about 504, Title II, Colorado Anti-Discrimination Act, we talked about the key issue being non-discrimination, equal access to services. Here, really the kind of the crux of the IDEA is provision of a free, appropriate public education, and FAPE, as it's referred to. And there's been certainly plenty of litigation over what do we mean when we talk about FAPE. And the landmark US Supreme Court case, Andrew F. versus Douglas County School District, has given us some very good guidance about what needs to be considered in the provision of FAPE. So in order to provide FAPE, the Individualized Education Program, the IEP, must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. The adequacy of a given IEP turns on the unique circumstances of the child for whom it was created. And this, I think, is really the key finding, is that every child should have the chance to meet challenging objectives. And if all the IEP does is just provide a little bit more than the de minimis progress from year to year, that's not sufficient. So further on when we talk about the IEP and what the IEP should be allowing a student to do, keep this in mind as kind of the core standard that the IEP should be measured against. So let's talk a little bit about the evaluation process for determining if a student needs an IEP, and then the components of an IEP, and kind of compare and contrast this with the 504 plan. So number one, IEP evaluation requires parental consent. Unlike the evaluation process for 504, here the school district does have a formal evaluation that requires that the student must be assessed in all areas related to suspected disability. The evaluation has to be sufficiently comprehensive to identify all of the child's special education and related needs, whether or not they're commonly linked to a disability category. So I want to expand that a little bit. I think one of the concerns with evaluations often is that they are not sufficiently comprehensive. So I'll give you kind of a hypothetical. A parent might say to the school district, my child is suspected of having a learning disability, or they've received this particular medical diagnosis. Their grades are really suffering at school. I'd like to have them evaluated to see if they need an IEP. And also, I want to mention that my kid is having a lot of behavioral challenges and emotional challenges too. It would probably be most appropriate for that school district to also look at the social, emotional, behavior needs of the child in addition to their intellectual and academic functioning. Even if the disability that the school district has put on notice is, a learning disability and not necessarily a behavioral type of disability like emotional disturbance or conduct disorder or something like that. If there's reason to think that that child has behavioral needs that's impacting their education, the evaluation should also collect some information about that as well. School districts need to use a variety of assessment tools and strategies to gather relevant functional, developmental, and academic information about the child, including information provided by the parent. Very typical in the evaluation process for the schools to send the parents questionnaires, want to get information about that student, do a social history report on that student. I think kind of a key thing that sometimes gets misunderstood is that it's important to consider information provided by the parent. That doesn't mean that the school district is required to, for example, follow the recommendations of the parent of the, say the private medical doctor that the parent has used who's providing information, or accept the parent's take on what should be provided to their child. They need to consider that information, certainly consider outside information provided by the parent, but that doesn't mean that the school district is bound to agree with, accept, implement that information. They just need to appropriately consider it. This is really critical. The parent is part of the IEP team that determines eligibility. So unlike 504, here the parent is a part of that team, and there is a number of procedural protections to ensure that the parent is able to participate. Reevaluation of that student to determine if they are still eligible under IDEA has to happen at least every 3 years. Certainly could happen more often than that. So for example, if the student got another medical diagnosis, or there seemed to be some new development and a reason to collect additional data, perfectly appropriate to ask that the district do some more evaluation, even if those 3 years are not up yet. So moving into the second column, some components of an individualized education program. An IEP is developed by the IEP team, which includes the parents, of course. Just 1 second here. Is there any issue with connecting to audio? It's okay? Okay, it will pop up on my computer. It looks like it's all fine. So So the IEP should include present levels of academic achievement and functional performance with the fantastic acronym of PLASP. If you are looking at an IEP, this information is really important, is to get a good understanding of where that child is at academically, because moving on to the next bullet point, one of the things that you would want in an IEP are goals that need to enable that student to make progress in the gen ed curriculum. So going back to this previous slide, every child should have the chance to meet challenging objectives. This is where this really becomes applicable. Are those goals appropriate? Are they sufficiently challenging? In order to develop good goals, you need to have accurate information about what their present levels of academic achievement are. Sometimes I've seen, a large goal kind of broken down into a short-term objective. I used to practice in Texas, and that was pretty common. But there's various ways that goals can be laid out in an IEP. But the key thing is that they need to be appropriate, sufficiently challenging. Again, placement, least restrictive environment, very similar to what we talked about with regards to 504. A description of how progress will be measured and reported. I think this is so critical. So often problems arise because parents are not clear on what's going on at school, and there perhaps is not terrific communication between the school district and the parent. So in putting together an IEP, I think it's important to give some thought about how is that parent going to stay informed about the progress that their child is making. It may address alternative assessments, for example, with regard to state assessments. And then this, I have lots of acronyms here because I didn't want to make the font tiny, and I'll explain all these acronyms. But if necessary, accommodations and or related services. So some examples are counseling, ST or speech therapy, physical therapy, occupational therapy, AT is assistive technology, may include a behavior intervention plan. And I realized that I skipped over an FBA, functional behavior assessment, where I was talking about the evaluation process. I think this is a good place to explain that because it's really tied to behavior intervention plan. Sometimes kids need some accommodations or services that are really targeted towards helping address behavioral concerns. And usually this is to develop that response, it's usually a two-step process. One is to do a functional behavior assessment, which means basically gathering data about that child's behavior. The best functional behavior assessments, it usually involve an observation in a variety of settings. So not just observing that kid in the math class when they hate math and they're not doing very well in math class, but seeing them in different environments as well. And what you're really trying to do with a functional behavior assessment is understand what are the antecedents, what are the kinds of circumstances that trigger behavior, what is that specific behavior, how are folks responding to that behavior, and are those responses effective, ineffective in terms of bringing about more positive behavior. So to give you an example, I'm going to go back to my hypothetical student who hates math class. If that kid is acting up in math class and the response is, well, we're going to suspend this kid, or we're going to send them to the principal's office, we're going to call their parent, tell the parent to pick them up. Basically, the response is to allow that kid in some form or another to get out of math class. That child might learn that acting up in math class gets me out of math class, and it reinforces that kind of escape behavior or avoidance behavior. That response is not very effective, whereas other kinds of responses might be more effective. So that's kind of the information that a functional behavior assessment should be putting together. And then based on that information, it may be important to develop a behavior intervention plan and say, based on the data we have, what do we think is the best way of addressing this type of behavior? So that's kind of an elaborate explanation of what a behavior intervention plan, or BIP, is and how it relates to an FBA. Also wanted to mention that an IEP must be reviewed at least annually. Again, it certainly could be reviewed more often than that. And the last thing I just wanted to mention before we move on is that really one of the key distinctions between whether or not a 504 plan or an IEP plan is appropriate is whether or not that child is going to need some type of specialized instruction, whether they're going to be able to access the general ed curriculum, perhaps with a few accommodations, or whether or not we really need to modify that curriculum or significantly modify how that curriculum is delivered in order to allow them access to FAPE. So that is usually the key issue in terms of eligibility for IEP. So often in practice, the way I look at this is a 504 plan is, you know, usually it's not a very detailed plan. It's kind of like a handful of almonds that sort of tides you over, whereas an IEP is often much more robust. And this is my visual way of thinking about it. I wanted to mention something that I've done in practice that I think can be pretty useful is take advantage of the fact that a 504 plan process for eligibility is so much simpler than IDEA. And while that IDEA evaluation is pending, and we're going to talk more about that in a minute, but while that is pending, the school district and the parent could put together a 504 plan to at least provide some accommodations, some protections, some services for that child in the interim while everybody's working on developing a more comprehensive plan. So I think that often is an appropriate approach, and that way the child isn't going for months and months and months without any help. So now we're going to move on to the process for getting an IEP. And you know, I use an image of a maze because I think that a lot of times parents feel that it's kind of excessively complicated, or there's a lot of hoops they have to jump through. I'd say that I think that can be how it tends to work, unfortunately, in practice, but the law is really much more simple. And so I'm going to focus on how this should work under state and federal law, and just, you know, keep that in mind that if it feels like there's a lot of runaround coming from a school district, that may not be appropriate given what the requirements are under state and federal law. So the first place to start is this concept called child fine. Child fine is a legal concept for basically the idea that the school district is, and actually I'm going to pause right here. I'm going to use the term school district for simplification going forward. Know that there can be scenarios like with charter schools or other kinds of situations where we may be talking about a different entity and the responsibilities of a different entity. But to keep it simple, I'm just going to go forward and use the term school district in any case. So under child fine, a school district would be required to find, identify, locate, evaluate, and serve children with disabilities under 21 years of age or graduation with a regular high school diploma. And this includes, but is not limited to, children who are homeless, who are wards of the state, who are attending private schools. I think a major factor about this is what is the district of residence. For a child with disability in Colorado, it's the school district in which the child lives on a day-to-day basis, but there are many, many exceptions. So, you know, it's important to kind of look at those exceptions if there's a concern that comes up about which responsibility, but typically it's the district that's serving the child who lives in that district on a day-to-day basis. This is a really, really broad concept. Basically what this means is even if a parent never asks for an IDEA evaluation, the district may still be responsible for starting that process. The school district needs to proactively be on the lookout for kids who are struggling and who there's some reason to believe that they might have a disability. So, yeah, I think of this as like, what are some red flags that could put a district on notice that there might be a child find issue? It could be, you know, a parent mentions to a staff member that their child has a medical diagnosis, so there's some reason to believe that child has a disability, and then on top of that, maybe that child's having some major behavioral issues in school, maybe their grades are struggling. You kind of put those things together and you ask, should this child be referred for an evaluation so we can find out what's going on with them and what kinds of services they might need. So even though school districts have this broad responsibility to start the process, that does not mean that parents can't start it themselves. So at any time, a parent can request an IDEA evaluation, even if the school district has never brought that up. The student does not have to go through multi-tiered system of supports or a 504 evaluation process before an IDEA evaluation can be conducted. Students, as I mentioned before, students could have a 504 plan pending the completion of an IDEA evaluation. So I think where, a source of frustration for parents is feeling like there's all these hoops they have to jump through. For example, if they're in a scenario where the school district has some concerns about their child, suggests that they go through the MTSS process and get progressive levels of support, and then they don't seem to be doing very well after that process, and now we're going to look at them for 504. Okay, they've been on 504 for a year, they're still not doing well. Okay, well now maybe we'll think about an IDEA evaluation. That's not the way it has to go. That's the way it sometimes goes, but there's no reason why, if there's concerns that that child has some real serious impact in terms of education, why you couldn't just start with the IDEA evaluation. And I think it's important to make sure that there isn't unnecessary delay in getting children appropriate services. So generally, the initial evaluation should be completed within 60 calendar days from the date of the parent's written consent. So this is pretty important. School districts will give parents forms to provide written consent for the evaluation, and once they get those signed forms back, that starts the clock, 60 calendar days. The IEP team should meet to determine eligibility within a quote-unquote reasonable period of time after the evaluation is completed, and the initial IEP must be developed within 60 calendar days from the date that the parents obtained, or the date the district obtained the parents' written consent. So for example, if a school district didn't schedule a meeting to discuss evaluation until, let's say 90 days after they completed the evaluation, that would raise some red flags, because that would kind of indicate that the school district has predetermined that that child doesn't need an IEP, because an IEP has to develop within 90 days of when the parents provide written consent. So best practice is that the school district should convene a meeting to discuss eligibility shortly after that evaluation is completed. If the school district refuses to do an IDEA evaluation, then they have to give the parent prior written notice, which is a specific type of legal notice that informs the parent what the decision of the school district is, and typically why the school district has reached that decision. And so that's important, because then parents understand where they are in the process and what the next steps are in terms of their legal rights. So the next slide has tips for requesting an evaluation. These are just some sort of practical things that I think parents should consider doing if they want to make sure they get a timely evaluation. Number one is to make that request in writing. Preferably to someone like a principal or the special education director, somebody who is in the administration, not just, for example, to the teacher's assistant or someone who may not be able to make sure that the next steps happen as they should. And then, of course, keep proof of that written request. I think in that written request, it's very helpful to be explicit and describe the child's disability, how it relates to school performance. If appropriate, include information about the child's diagnosis and medical records if that information is available. And then certainly, I think it's helpful if the parent provides their contact information. Ask for a meeting to discuss the specific types of testing. Remember how we discussed that an evaluation should address all areas of suspected disability and or impact on that child's performance. And then also to follow up with the district and ask for that written consent, because it's really that written consent that starts a 60-day clock. Follow up, keep records of all communication with the school district. You often hear lawyers say that if it's not in writing, then it didn't happen. Next step, school district does the evaluation. There is an IEP meeting to determine eligibility. And here I showed that you can have a little detour, right? You could have a meeting where the school district says, you know, based on the evaluation we did, we don't think this kid qualifies. And the parents might say, well, I think your evaluation is not very good for the following reasons. The parent can then request a free independent educational evaluation. What this is basically a second opinion that is conducted by somebody who is not employed by the school district, but who is paid for by the school district to, so it's on the school district's dime, but it's an outside evaluation to get more information. And then typically in the process, the parent would take that information back to the school district and have a meeting to redetermine if that child actually is eligible. And then if the district agrees that the child is eligible, then the next step is to develop an IEP. Sometimes that happens at a second meeting. So you might have one for eligibility and then one to develop the IEP. Very often it happens at the same meeting. Oh, here we go. So what happens when there's disagreements? There are several different options for resolving a dispute, and the Colorado Department of Education's website has a lot of really good detailed information about these topics. One option might be to have a facilitated IEP team meeting. So what that is have somebody who can act as a facilitator to make sure that meeting is productive and that all sides are heard and hopefully resolve conflicts. Another option is mediation. A mediator is neutral. They're not like a judge. They cannot force anybody to agree to anything, but they can facilitate conversation and try to resolve conflicts. So in some ways that process is pretty similar to a facilitated IEP team meeting. There are differences as well. Again, I recommend people look at the CDE website. There's also some other options. Another one is a state complaint. So filing a formal complaint with the Colorado Department of Education, asking the Department of Education to investigate the matter. And if they find violation of the IDEA, then they have the ability to require the school district to take certain action. There is a 1-year deadline to file that complaint. So it needs to address, violations of the IDEA, ECEA that occurred within the previous year. And then the last option is a due process complaint. So in most cases, there's typically a 2-year deadline to request a due process hearing. There can be some exceptions to that. Parents would make that request to the Colorado Department of Education, and then it gets sent to the Office of Administrative Courts. And there is a formal hearing in front of an administrative law judge. This process is a prerequisite for a lawsuit under the IDEA. And there's also many situations where it may be a prerequisite for a lawsuit under Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. So this process, due process, this is essentially litigation where typically both sides have lawyers and there's a whole lot of procedural rules and it can be fairly complex. So I would say that's kind of the sort of the big guns approach to resolving a problem, particularly one if the parents feel that the other types of options just aren't appropriate. So kind of the last thought I wanted to leave everyone with is that I think of education law as an unplanned city. There can be a lot of scenarios where it feels like the law is just unnecessarily ambiguous, or there's so much overlap between 504 and IDEA, and it's very murky. And I mean, that's, as a lawyer, I have those thoughts. I would say that education law, like every other area of law, is really a product of history and various players, Congress, state government, administrative agencies. So it can be a pretty complicated area to practice in. I think it's also pretty interesting in that there can be a lot of opportunity for new arguments, new ideas, because there's so many different things at play. Okay, so we're here with part 2 of protecting the educational rights of students with disabilities. Again, my name is Catherine Newell. I'm an attorney with Griffin, Newell, LLC. And this part of the presentation is going to focus primarily on school discipline matters, mainly on expulsion and on the legal protections for students who are in that type of situation. Oh. So we'll start with an overview of the presentation. We're going to talk a little bit about the legal framework regarding expulsion. Again, my focus is on for purposes of this presentation, is on K through 12 public education. I do work on cases involving higher ed, and you can have some similarities in terms of expulsion from colleges and universities, but that's not the focus of this presentation. So K through 12 public education, and then we're going to move on to legal protections for students under the IDEA and Section 4, as well as other issues to consider related to expulsion. Again, this is just general information about these topics. It's not meant to be advice about a particular situation. And keep in mind that, education cases are often very fact specific. So I wanted to start this presentation with a quote from Franklin Roosevelt. And the quote is that democracy cannot succeed unless those who express their choice are prepared to choose wisely, and that the real safeguard of democracy, therefore, is education. I wanted to start with this because before you can really move on to the issue of school discipline, you have to kind of talk about this broader issue, which is the right of students to education in the first place. And I think that there is often a disconnect between about the importance that we place on public education versus the legal rights that may be affected. So what I mean by that is, I think my guess is that the majority of people would probably assume that because education is so fundamentally important to our democracy and to our society, that there just must be some fundamental right to a public education that is protected by the US Constitution, because as I think Roosevelt pointed out, it's really at the bedrock of our society. And if that's your perception, then this case, San Antonio Independent School District versus Rodriguez, may come as a shock. So the picture here is, I think kind of represents this concept that, do I have a right to education protected by the US Constitution? The answer must be yes, but then when you start looking at the case law with your little legal device, what you see is no, 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 no. So San Antonio Independent School District 1973 case that says that education, of course, is not among the rights afforded explicit protection under our federal Constitution, nor do we find any basis for saying it is implicitly so protected. As we have said, the undisputed importance of education will not alone cause this court to depart from the usual standard of reviewing a state's social and economic legislation. So to put this in some context, this case was about school financing in Texas. And the question was, should state law regarding how school districts are financed in Texas be reviewed under rational basis review, which is the usual standard for reviewing a state social and economic legislation, which is kind of the lowest level of review, essentially, is what the state is doing rational? Or should it be reviewed under a higher standard, like strict scrutiny, that might require kind of an additional burden of proof on the part of the state? And what the US Supreme Court said is nope, rational basis is good enough, even recognizing how important education is. This case, of course, has a lot of implications for school finance litigation. And after this case, I think, this is kind of an aside, but I think there was a real focus to look more at state constitution and the rights that might be afforded under its state constitution that might be a little bit more robust for students in terms of school finance. But apart from school finance, it also has implications more broadly in terms of education, including school discipline. So another case that came 2 years after San Antonio Independent School District was Goss versus Lopez. And in this case, the Supreme Court, US Supreme Court, was asking the question, what level of due process should a student receive before they lose education? So the US Supreme Court recognized that even if education is not a fundamental right protected by the US Constitution, students do have a property interest in public education that entitles them to some due process protections before, actually I think in this case it was about a suspension, but it would also, the same argument could apply to expulsion. So at a very minimum, due process for a student includes oral or written notice of the charges. And I think this is an important detail. There need be no delay between the time notice is given and the time of the hearing. So what that means is, you may get notice, but it may be right before your meeting with the principal where they tell you that you're going to be suspended, or they tell you, they ask you to kind of discuss the issue of suspension or expulsion, and you don't really have a whole lot of time to prepare, gather information, etc. The student needs to be allowed the opportunity to give an explanation. Actually, before that, they first need to have an explanation of the evidence that the authorities have, so it can't be totally baseless, totally arbitrary and capricious. And then the student needs to be allowed the opportunity to present their side of the story. That doesn't mean that, if the student chooses to say nothing, that the school district can't do anything. No, it just means that they have the opportunity to provide an explanation. And so at the bottom, I have the quote that the due process clause requires at least these rudimentary, and they are rudimentary, precautions against unfair or mistaken findings of misconduct and arbitrary exclusion from school. Now, I do want to mention that, like I said, I think Goss v. Lopez was looking at a fairly short-term suspension for a longer absence of school, like expulsion. There may be arguments that you can make about additional levels of due process that should be required, but at the very minimum, these three elements need to be met. So you gotta check some boxes. Next slide, I wanted to kind of come back to Colorado and talk about some of the grounds for expulsion under state law in Colorado. And these are found in Colorado Revised Statute, section 2233-106. These are just a handful of grounds that a school district may use to expel a student. As you'll see, schools have a lot of discretion when it comes to expulsion. So some examples are repeated interference with a school's ability to provide educational opportunities to other students, continued willful disobedience or open and persistent defiance of proper authority, willful destruction or defacing of school property, behavior on or off school property that is detrimental to the welfare or safety of other pupils or of school personnel. There is have a new change in the law. There's some exceptions for very young children, preschool through second grade, that limit the grounds for expulsion. But in general, school districts have a lot of discretion, and these are really broad categories, right? So I'll give you an example. You could have, say, an 8-year-old child who's in 3rd grade who draws on the wall with a crayon, and theoretically the school could remove them before defacing that property. Continued willful disobedience or open and persistent defiance of proper authority is also a very, very broad category where you can think of a number of childlike behavior that might run afoul of that issue. So we're going to start with the premise that state law has given school districts this incredible latitude to proceed on expulsion. And then we're going to talk about what level of or what are some of the protections for students who are in that situation generally. And then we'll move on to some additional protections for students with disabilities. So the process for expulsion in Colorado, and some of the relevant state statutes are listed there. Students have the right to a hearing before a hearing officer, which is either the superintendent or their designee. The superintendent shall issue a written opinion within 5 days of the hearing. And the school district is encouraged, not required, encouraged to consider factors such as age, disciplinary history, disability, seriousness of violation, whether violation threaten the safety or students or staff, and the appropriateness of a lesser intervention. So, often the purpose of having a hearing is to talk about those factors in addition to whatever disputes there are about what actually happened. But school districts are not required to take those factors into consideration in terms of deciding what punishment they want to give out. Once the student receives the decision, they have 10 days to appeal that decision to the board. So it's a very short deadline. Student parent has and then typically there's a hearing before the board. Then the student parent has 5 days after receiving official notification of the board's action to notify the board that they want court review. The board may issue a statement of the reasons for the board's action, and then the student parent, must issue a statement of the reasons for the board's action, and then the student parent has 10 days to file a court petition. And one of the main issues the court is looking at is whether the school district exceeded its jurisdiction or abused its discretion. So going back to that earlier slide, school districts have a lot of discretion. So I think that those cases can be pretty challenging for that reason. There's a lot more detail to these laws. I didn't want to kind of go into the weeds on this, but the takeaway is that there are some very, very, very short deadlines for parents and students, and that school district expulsion decisions are typically pretty hard to challenge. Services for expelled students. So first off, an expulsion cannot last longer than 1 year, which is really a pretty long time. The school must provide information to parents about educational alternatives. Student parent can ask for educational services from the school. In terms of those educational services, they need to be designed to enable the student to return to the school where they were enrolled prior to expulsion, to successfully complete the high school equivalency exam, or to enroll in non-public, non-parochial school or in an alternative school. This is, again, really, really broad. I mean, it doesn't say that it has to be for X number of hours or address specific subjects, or even that it has to occur in a brick or mortar building. I mean, you could certainly imagine that there are school districts that may have an online type of program for educational services. And I think particularly where you have online programs or you have expulsion programs that are only a couple hours per day, that puts an enormous burden on families in terms of supervision for their children. having childcare for their children, and impacts parents' ability to work. So it can be another thing to understand too is that a school district is not required to provide educational services to a student who is suspended or expelled while receiving these services until the period of the suspension or expulsion is completed. So if you have a kid who is really struggling and has a lot of behavior issues and they get expelled from their regular school and they go to an expulsion program, and lo and behold, that's not the fix, and they continue to have behavior problems, and they end up getting expelled from that expulsion program, then the school does not need to provide them with anything pending that expulsion or suspension, as it may be. I think another component of this is that based on my research, I think it's very unclear what services a student is entitled to if they move out of the school district that expelled them during that period of expulsion. So, you know, give you just hypothetically, say a student is lives in Colorado Springs and attends school there and gets expelled in Colorado Springs, and then maybe for a year, and during that 1 year period, the student's family moves to Denver. I think it's really unclear as to what right to educational services that student has if they move out of that district. And the reason why this matters is that school districts can deny admission to students who have been expelled during the preceding 12 months. There's also other bases where the school district might deny admission. So say that student moves to Denver, tries to enroll at in a school district in Denver, and the Denver school district says, nope, we're not going to take you because you've been expelled. What is available to that student? I don't think, from my research, that state law is very clear about how that would get resolved. So now we're going to move on to additional protections for students with disabilities. And I think if you can tell, my opinion, these protections are really, really important because there's just under, plain vanilla state law and federal law, there is not a lot of protection for students in general in school discipline matters. And so if you have a student whose behavior is a result of their disability, it's really important to think about how they might receive an additional level of protection. So first part, the IDEA entitles students to what's called a manifestation determination review, or MDR, in some situations. There are also, I want to mention, protections in some cases for kids who are not yet found eligible for IDEA. For example, the parent has requested an IDEA evaluation and that evaluation is pending. That child might also be entitled to an MDR if there was a certain type of disciplinary issue that arose before that evaluation was completed. So students under the IDEA are entitled to an MDR when one of two types of things happens. Either one, they are removed from the removal from the current placement exceeds 10 consecutive school days in the same school year. So expulsion is a good example of that. Or removal from current placement exceeds 10 school days in a school year, and there's a pattern. So you have a bunch of short-term suspensions that are all for the same basic behavior, and you get to a point where now that kid is being removed in total for more than 10 school days in a school year because of this pattern of behavior. Under either one of those two circumstances, that student would be entitled to a manifestation determination review. A MDR must be held within 10 school days of the decision to change placement because of a disciplinary violation. The purpose of the MDR is to determine whether there is a manifestation. And there can be a manifestation because either A, the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or the conduct in question was the direct result of the school district's failure to implement the IEP. And you could certainly have scenarios where you can check both of these boxes. It's a direct and substantial relationship. It's also a failure to implement the IEP. On that second point, I want to mention that it's the IEP you have, not the IEP you want. So it's important to have a good IEP because should you be in a situation where there's a manifestation termination review and you're asking the question, was there a failure to implement the IEP? If you tried to make the argument like, well, no, they followed the IEP that was in place, but I think the IEP is all wrong. I think that the IEP should have addressed behavior, provided these kinds of accommodations. That's not going to go anywhere. It's looking at the IEP that currently exists. So let's talk about the outcomes of a manifestation and termination review. If there is a manifestation, then there can be some cases where that involve weapons, illegal drugs, serious bodily injury, where the school district may still place that student in an interim alternative education setting for not more than 45 days. That's often still a much better outcome than expulsion. Otherwise, the student has to return to their placement unless the parent and the school district agree to change the student's placement. So you could have a scenario where everyone agrees it was a manifestation, nonetheless they feel that that placement is inappropriate and they agree to change it to a different placement, maybe a certain type of program, for the purpose of benefiting that student, but not as a disciplinary punishment. Again, that's not the same as expulsion. Also, there are additional requirements regarding functional behavior assessments and behavior intervention plans. So just to sum it up, if there is a manifestation, and we're not talking about a scenario that involves weapons, illegal drugs, or serious bodily injury, then typically we're talking about returning that child back to their regular placement, not expelling them, and providing some additional supports to address behavior, and there's lots more detail about that. What if there's a determination that there is no manifestation? Then the school district can proceed to discipline that student to the same extent as if they did not have a disability. So in general. So that means that student could be suspended, they could be expelled. They're kind of treated for all intents and purposes as any other student would be who was not covered by IDEA, with an exception that I'm going to talk about in a minute. So the school district must still provide an functional behavior assessment and behavior intervention services as appropriate. And I think this is really critical too. The parent can challenge that decision by requesting a due process hearing, and that happens on an expedited timeline. Due process hearings already have some pretty short timelines, but when you're talking about a due process and MDR, that happens very, very fast. I believe from memory too that there are some scenarios where a school district could request a due process hearing. I just haven't seen that happen very often, but that certainly is, typically the scenarios that the school finds that there's no manifestation, the parent disagrees, then the parent files an expedited due process hearing. So here's kind of the key thing I wanted to mention, is that even if there is no manifestation and that student is expelled or suspended, that student is still covered by the IDEA, which requires that they still receive a free appropriate public education, even if they're expelled. So this is really, really critical. On the previous slide, I talked about educational services for kids who are expelled, and some of the concerns about those services maybe being pretty minimal, or that kid not receiving any services if they're expelled again, move, etc. If you're covered by the IDEA, you're still entitled to FAPE even if you're suspended or expelled. So it would, in many scenarios, it would not be appropriate for the school district just to put that child into an expulsion program without any consideration as to whether that expulsion program is going to be sufficient to allow that child to continue working on their IEP goals and to receive FAPE. And this is really critical, I think, for for kids with disabilities and one of the major protections under the IDEA. So I now want to kind of just touch on Section 504, because Section 504 has a legal requirement that is pretty similar to an MDR under IDEA. In my previous presentation, I talked about how under 504, there needs to be periodic reevaluations. Well, one example of where you would need to have a reevaluation is before there is a significant change in placement. And the U.S. Department of Education's Office for Civil Rights, OCR, considers an exclusion from the educational program for more than 10 consecutive school days or 10 total school days with a pattern of removal to be a significant change in placement requiring a manifestation determination. So in practice, if a kid is on a 504 plan and there's an issue about expulsion or kind of a long-term suspension, pattern of suspensions, the school district will typically conduct what's going to look like a manifestation determination review in order to meet this legal requirement. But there's certainly differences too between this process and the MDR and the IDEA. For example, you don't have a right to an expedited due process hearing under 504. The issue about continued FAPE if you're expelled is different. So, I think that there are some protections under 504, but certainly not as robust as under the IDEA. Another reason why, if a child's disability is something that really is going to implicate behavioral issues, why from sort of a student's advocate perspective, a lawyer's perspective, IDEA is probably the preferred means of addressing that kid's needs. So I wanted to just mention some other considerations that can come up in school discipline matters. One issue that I'm often thinking about is whether there might be a related juvenile justice or criminal matter, or the possibility that there will be one in the future. So even if a citation hasn't been issued yet, or a charge hasn't been issued yet, or there's been no contact with those systems yet, that doesn't mean that there might not be something that's coming down the line. If that is a concern, depending on the conduct in question, then I think it's often advisable for students or their parents to speak with a defense attorney before providing information to the school district. And that is because of concern about the Fifth Amendment, making incriminating statements, providing information that could be used against the child in a court procedure, for example. The Family Educational Rights and Privacy Act, which I addressed below, does provide some protections regarding privacy of educational records, but FERPA has a lot of exceptions, and I don't think it entirely alleviates the concern about self-incrimination and information that might be used against that student. So the second thing I wanted to mention is that if there's inaccurate or misleading information in the education records, it might be possible to address that issue through FERPA, the Family Educational Rights and Privacy Act, and or the school district's board policies. I mention this because, you might have a scenario suspended, and let's say it's just a 3-day suspension. It's a real short-term suspension. You're not entitled to an MDR. There's not a lengthy process for challenging that. Maybe all that's really required is just to give the student the opportunity to tell their side of the story, but there's not, board review and all these additional layers of protection in most cases. But you have a concern that there's information in the kid's records that's just flat out wrong. One thing to think about is whether or not that information can be corrected through a request to amend the records under FERPA. School districts typically have their board policies available online through their websites. I am frequently looking at school district board policies. There's usually very useful information there, and Typically, I've seen school districts have a policy that addresses how a parent or a student can go about requesting an amendment of their records. So that's often useful to look at and be aware of. So the last slide is that knowledge is power. So, you know, these situations can come on really fast, and there can be very, very short deadlines. And it can be a real struggle between figuring out what happened, what information to provide, how quickly you need to provide it. I think that it's very helpful for any parent to be aware of the process ahead of time, so that if unfortunately they're faced with that scenario, they know what their options are without having to get up to speed when they're in the middle of a crisis. So, you know, I hope that this presentation has helped inform people about options for addressing these types of matters, what the rights are for students, and particularly for students with disabilities. So with that, I just want to thank you again for participating and being a part of the presentation, and thank you for your attendance. I hope this information was helpful.